Why don't we go ahead and get started so that we can at least stay generally on time. I'm Doug Blaze. I'm finishing my term as chair of the Access to Justice Commission. I'm also associated with the law school, but I have no power over parking. And we apologize for the problems that many of you have encountered. Welcome to our lives. But anyway, I want to welcome everyone briefly. This is a terrific program today. We have some great presenters on critical topics. But I think more important and most important, I want to thank you, all of you, the participants, the attendees. I want to thank Ann Louise for helping to put this together. Because at least to my mind, this is the most important work we do as lawyers. And I think it is likely the most fulfilling and satisfying work we do as lawyers when we help the less fortunate that don't have access to legal assistance, other than through folks like you. The reality is, and I will be very brief because I know Justice Clark may repeat some of this, but redundancy is an important teacher in this regard. There are at least 1.5 million Tennesseans who qualify for free legal services, and it is impossible for legal services to meet that need. In fact, legal services, if they're lucky, carry 10, 15% maybe of that need. You know, as a result, in our last legal needs study, we learned that 60% of those qualifying for legal assistance that have a legal problem don't do anything because they've lost hope. They don't think that there's anything that likely can be done, or there aren't any resources to help them. That's where you come in, and that's where this program comes in. The good news is, last year, 41% of Tennessee lawyers collectively provided nearly 600,000 hours of pro bono assistance. In fact, Tennessee, and many of you may know this, if you don't, you really should, that Tennessee is a leader in access to justice across the nation. Tennessee is viewed as one of the leading states. And one of the reasons is, and one of the most recognized initiatives out of Tennessee and our access to justice efforts is the Faith and Justice Alliance. It's rapidly spreading across the state to provide assistance to those in need, and I'm really excited about the expansion that's now taking place in East Tennessee, thanks to people like Ian Hennessy, our new Commissioner Bill Coley, and all of you that are here today. So thanks, and thanks for taking up the challenge. I also have to thank the incredible Ann Louise Workland, who is now back in, did you ever have a class in this?
Yeah.
She is just terrific and makes our entire Access to Justice program go. She coordinates well with legal services providers. She assists the Supreme Court. She assists the Commission. She does a number of incredible things. And the other reason that Tennessee is a leader, and I think actually probably one of the primary reasons that Tennessee is a leader in access to justice, is our Supreme Court. They are unanimous in their support for access to justice efforts, and that is continuing. It has continued over an 8-year period already. And one of the big reasons our Supreme Court is so supportive is Justice Connie Clark. In fact, she helped with Margaret Bem start the Faith and Justice Alliance. You know, I've had the great honor to work with her over the past 7 years on access to justice, and even more closely over the last 2 years. And her support is demonstrated by her participation, her attendance here today, and she will be here all day, and then brave hail, and like the mail office, and everything else to try and get back to Nashville this evening. You know, she supports access to justice. I've learned this because she thinks it's the right thing to do. But I think more importantly, she supports access to justice because that's really where her heart is. She cares, and she really wants people in need to be helped. And I learned so much from her. I continue to be inspired by her. I think you all are too. And anyway, thanks, and please join me in welcoming Justice Connie Clark. I was going to comment.
Doug, thank you, and Dean Blaze, thank you, and you're always going to be Dean Blaze to me. But I begin by thanking the University of Tennessee Law School and Dean Melanie Wilson and a number of other folks, including Brad Morgan, who've made it possible for us to be here today. I do want to thank Doug Blaze, and I want to add to what he very little has said about himself. Today, March 31st, is actually the end of the terms on the Access to Justice Commission for our last three original commissioners, people who have been with us since we began this commission. Doug is going out as chair. He's completing a 2-year term in that regard. But he and Buck Lewis, who may be here today, and 8 other people to begin with, and then their replacements over time, over the last 8 years, are the people who have really been able to carry out the vision that we have in Tennessee today. We would not be able to have done it or to continue to do it without them. And I'm very grateful to Doug and to Buck and to all the other members, old and new, returning and leaving. And so I just want you to think about them for a minute. I want to do a very brief sort of reminder for those of you who are already familiar, an introduction to those of you who may not be, about how we got here. And it has to be very quick because we are running a little bit behind. But we start every time by saying this. I truly believe that the attorneys in Tennessee who work for our 4 Legal Service Corporation funded, our legal aid societies, and they're called different things around the state, are among the very best attorneys we have in the state of Tennessee. Some of them, I'm grateful to say, are in the room today, and many of them you know in East Tennessee. They are the best, and so in anything where we talk about we need more attorneys and we need more help, it is not about that they can't do what they do well. It is about how much there is to do. Doug gave you some updated numbers. I want to tell you historically that the numbers we had when we started talking about this in 2007 and 8 were from a study that had been done in 2003. So going back that far, we said there were about 1,100,000 Tennesseans who every day live at or just above the poverty level. On any given day, we think that 70% of them have civil legal problems. They don't all need to go to court, but they've got some problem that could be improved or solved if they simply had some legal advice. That's 1 out of 5 Tennesseans on any given day 10 or 12 years ago, and as Doug told you, even more people today. But they can't afford to pay for a lawyer. And so we've said today, the numbers of legal aid attorneys have been going down in Tennessee and everywhere else for years and years as Congress has continued to defund the programs. We have about 1 legal aid attorney for every 14,000 eligible people. All you have to do is do that math and know that those folks, no matter how good they are not going to be able to handle all the cases. And there are now federal limitations on the kind of cases that they can take. So we began to say, what are the other resources? And then there were just over 20,000 lawyers in Tennessee. Today there are about 22,000. There are licensed attorneys. If you remember your oath or if you have read the rules of conduct that guide you, you know that there is in them an obligation to serve those who are in need, an obligation to provide services without expectation of pay to people every year. And so what a lot of smart folks decided, and I always give Buck Lewis a lot of credit because he was president of the TBA at this time, is that all they need is the motivation to get started. And in Tennessee, starting with the Tennessee Bar Association and then moving to the Supreme Court, we said we can help. We can help motivate, and as a court we're going to do that. We're going to make this for us a public policy initiative. We're going to pledge the support of all our members. We're going to say that will continue now and going forward. We went out and studied this. The 5 of us went across the state. We had listening meetings, and in 2009 we came back and created the Access to Justice Commission. We don't have, what I regret today is that the picture we took on that day doesn't have everybody in it. And we don't have good pictures from the very beginning of everybody. But those folks were the leaders, they were the best and brightest, and they continue to be. We had a summit. We've done a whole lot of things. We said to the commission, you're going to be our strategic planners. And we have, since 2012, or since 2010, had a number of strategic plans come forward. And starting in 2012, we added faith-based initiatives. And I'll just stop and say, because there are some more people coming in the room, and I know most of the seats are now sort of down front or on these ends, so don't worry about that. Walk on up the steps, down the steps, or around folks and find a good seat. The commission set 4 strategic goals, and they have continued. One is to involve more lawyers and law students, and that's part of what brings us here today. 2 is to provide greater educational opportunities, and that's part of what brings us here today. 3 is to make the justice system more user-friendly. And that's why we really need you. And 4 is to remove all barriers to access to justice. Now this one, we will each be working on for the rest of our lives, and then so will you, and so will the next generation. And we're not sure we'll ever get to 100% capacity in accomplishing this. But it is a goal that we take seriously and we want to accomplish. And so we're going to continue. Where are we going to find the people in need? That was our next question. We got 20,000 lawyers. We know how to motivate them, help educate them, and then ask them to do their duty, create aspirations, as we have now, aspiring to do maybe 50 hours a year of pro bono service. That's 1 hour a week. But then we have to figure out how to match the lawyers who get excited about this with the people who are in the field. And so we began saying, where do people go when they have legal issues? And the traditional places are legal clinics at courthouses. They're usually sponsored by bar associations. And a lot of those have been working for a long time, and they're excellent, and we will continue to have those. Probably always is our first model. Many schools now have clinics in law schools. UT is a leader in that area, allowing law students from their very earliest days to get involved. But that's not the only place that people go. A lot of times they don't trust walking into a law school. They don't trust maybe walking into the courthouse on a Saturday morning. They may not even trust walking into a lawyer's office, especially if it's in some urban high-rise area in the downtown area. They may not have transportation to get there. And if they know they've got a problem and they're not sure how serious it is, they may not trust people they don't know to tell their problems to. They don't know what's going to happen once they have revealed that. And so we looked around and we said in our communities where people often go are houses of worship, where they attend, or maybe just some that are in their community. They don't go and say, I have a legal problem. They often go to the pastor or the rabbi, or whoever the leader is, and say, I lost my job. And as a result of that, everything else is happening to me. My child is seriously ill, but I now don't have insurance to pay for it. I haven't been able to pay my rent or my mortgage, and now I'm about to be evicted. Those are the kinds of problems they talk about, and often neither they nor the persons hearing them speak understand that there are legal components and perhaps legal ways to help solve the problem. It may not be possible to get that person another job, but it may be possible to make sure there are unemployment benefits if those are available, to figure out how to get a child on TennCare, to take other steps that will help alleviate the problem. And so that's what we decided, that we can connect with people in the places where they go. Some lawyers like to work within their own faith communities. Other lawyers and other houses of worship say, we're not as necessarily need to serve our own folks, but we're happy to house a place in the community. We'll have a clinic here, and maybe more people who live around us will feel safe coming here than going downtown to your law office. And so we have continued that. We allow attorneys to participate in a number of places, and although we call it now not just the Faith Alliance, but the Faith and Justice Alliance, because our goal now is to extend that to all kinds of places in the community where people go. And so we have schools that participate. We go into rehab facilities now. We have arts organizations. We have immigration clinics in a number of places. We are right now exploring how to extend this concept literally into jails and prisons. Because we had a lawyer who used to be a police officer come to one of our trainings and say, you know that a lot of people sitting in the local jail in Nashville, which is where he was from, have civil issues, not just criminal issues, or they're about to get out and they have issues about jobs and health care and all the other kinds of issues that other people have. You could help them tremendously in a setting that you probably were not thinking about because you think of it as being only criminal. And so we will now send Ann Louise and our pro bono coordinator, and we're in the process of hiring a new one right now, but we will help set up trainings. We will do all kinds of things to make any group, any community group, interested and involved. And attorney training is a key component. And that's precisely how you get here today and why we are able to offer low-cost CLE for you. We hope that you'll enjoy it. We know that helps you meet another guideline or rule that you have for CLE. But we want you also to take seriously the obligation and the responsibility and the privilege that we hope to impose upon you, that you will now consider giving back and participating. Today we have a great agenda. You're going to have experts in each of these areas talk to you about issues that you may have learned in law school or you may not. Some of you may practice in these areas and a lot of you haven't thought about them in a number of years. But these are many of the most basic issues that people coming in to see you wherever they appear, whether it's at a law office or a courthouse clinic or a church clinic or a school clinic, wherever it's held. These are the basics that you need to know. And you don't have to know a lot to be able to either give them advice or point them to someone who can give advice. This is our Supreme Court today. We've had 4 members, as you know, since the retirement of former Justice Gary Wade in September. In mid-February, a 5th member of our court was confirmed by the legislature, Roger Page. So there are 5 of us. We just haven't had our group picture taken yet. That's going to happen in a few weeks. But what we want to remind you is that through your participation, you can really change the lives of Tennesseans. I hope there's a lot that you love every day about the practice of law, but some days are just grinds, and they are for me too. Doing this work will show you that you can literally change the lives of Tennesseans one life at a time by just appearing at a clinic or answering a telephone call or agreeing to take on a case and go to General Sessions Court and get somebody a slow pay motion so that they don't get thrown out of their apartment if they can still pay a little bit each month on rent. Thank you for knowing enough about that to show up today. Thank you for the opportunities that you are about to embark on and undertake. The Supreme Court really does believe in this, and that's one of the reasons that I'm going to spend the day here with you, because I really believe in it. But in this room right now, with the numbers that are here and the others that will drift in when they finally find places to park, we've got a lot of power to save and to help a lot of Tennesseans. So thank you very much. I think you're going to have a great day, and I guess I'm turning this over now to Ann Louise.
So we're running a little bit late, but we'll make it up during breaks, so please don't worry about that, and I apologize again for the parking issue. There's always something, as you all know. I want to introduce our first speaker today, Terry Woods. Terry is the pro bono manager for Legal Aid of East Tennessee. She joined Legal Aid of East Tennessee in 2000. Before that, she was in private practice. She is a UT Law alum, and she was editor-in-chief of the Tennessee Law Review when she was here. She received the TBA Harris A. Gilbert Pro Bono Volunteer of the Year Award in 2000, the Knoxville Bar Association's Law Through Liberty Award in 2004, and the East Tennessee Lawyers Association for Women Spirit of Justice Award in 2011. She's a member of the Tennessee Bar Association's Access to Justice Committee, and she also is a member of the Commission's Access to Justice Commission's Pro Bono Committee. So please join me in welcoming Terry.
Ann Louise is going to, can you hear me with this? She's going to pass out a couple of things. One is about pro bono generally, another is about debt collection. First, I need somebody to be my timekeeper. Shelby? Okay. Because I will go over if you stop me, and Daniel Ellis is just going to be unpleasant about that. As Doug and Justice Clark mentioned, there is an enormous unmet legal need that poor people have for a lawyer. And Doug alluded to the fact that when the Tennessee Alliance for Legal Services did a study of what the legal needs are, one thing that they found is a significant number of people don't look for help. They say, that's just the way it is. There's nothing I can do. They particularly didn't like going to see a lawyer. And the reason for that, you would think, it's money. They thought they couldn't afford a lawyer. But actually, one of the main reasons, according to this study, is they have had unpleasant experiences with the justice system. And they didn't know what their lawyer was talking about. So at Legal Aid, we make a concerted effort to write at a 5th grade level and to try to explain things as simply as possible. And when you start trying to do that, you realize how difficult it is, because once you start advising someone, you don't want to leave something out, even though, you know, it might not, it's a remote possibility, or, you know, it's a little bit complicated, and they maybe don't really need to know that, but you feel like you have to explain it. So, for a long time, I have been in the mode of trying to make things very simple. And if I sound to you like I'm speaking to you as 5th graders, it's just a habit that I have, that's become a part of me, not because I think you aren't going to understand what I'm talking about. Another thing that this legal needs study said is that people who don't go to lawyers, where do they get help? If they look for help, and they go to the internet, they go to their neighbors, and I'm sure we have all had the experience, bad experiences universally, with people who have gotten legal advice from either of those sources. But a lot also go to their churches. So that's what we're trying to help churches respond to this need. The first Faith and Justice Alliance legal advice clinic that we will have in the Knoxville area will be on May 8th at First Baptist Church, which is over beside the City County building. And we need volunteers to participate in that. So over the course of today, if you think that you'd be interested in coming to that clinic, if you would give me your name and email address, and then I'll get in touch with you closer to that time. You just pass that around. And as I said, you know, think about it over the course of the day. The most common request that we get at Legal Aid for service is in the field of family law. But when you look at the legal needs study, remember, we're getting requests from people who are looking for help. When you look at the actual need and factor in those who aren't looking for help, consumer problems are the significant legal issue that poor people face, not surprisingly. Every month, we do at our Saturday bar clinic, which is a legal advice clinic, we do what we call debtors survival camp. And that is for a specific group of our client constituency. That is clients who are judgment proof, who have called us to get bankruptcy, but they don't need a bankruptcy because they're judgment proof. So we try to help them deal with debt issues. And we're doing that this Saturday. So if you're interested in that being a service you'd like to provide, I invite you to come on Saturday, and you can sit in with me when I do it and decide if you want to do one of those classes or do it as a team with some other lawyers or with me. But a lot of what I tell you about today is what we cover in that Better Survival Camp. Before I get to the specifics on consumer law, I want to go over one of the handouts, which is handling pro bono files. There are a lot of misconceptions about doing pro bono work. One is that people assume it's just poverty law. Like that's a special area of the law. But poor people have the same problems that everybody else has. I have a lot of volunteers who will accept a referral and they come up against a client, their own client now, who has an unreasonable expectation. We try to manage expectations before we make the referral. But if you have a pro bono client who wants you to pursue a case to the United States Supreme Court, that does not mean you have to do that. You determine the service that's needed. And if a client has an unmeritorious claim, while you have a duty to do pro bono, your duty not to pursue an unmeritorious claim trumps that. And if you have a problem with one of the clients that legal aid has referred to you, we can help you manage those clients' expectations. If a case turns out to be something you didn't anticipate, we can help you withdraw. One thing, in every letter, when I send out a file to volunteer, the letter says if you need a court reporter or a mediator or some other professional, we may be able to help you find a pro bono volunteer to do that. But you have to tell us in advance. And it also says in every letter, if you file a lawsuit, use an affidavit of indigency. The Supreme Court rules create a presumption that anyone who is eligible for our services at legal aid is indigent. So you should be able to file on an affidavit of indigency, which eliminates your need to sign a cost bond. Yet, frequently through the year, I have a volunteer call me and say, well, now what do I do about these court costs? So you don't have to worry about the court costs. File it, in most cases, on an affidavit of indigency. One complaint we get, and I will tell you that before I came to legal aid and I was doing pro bono cases for legal aid, I was more guilty of this than any other volunteer I've got, and that is that I didn't want to fill out the paperwork that they sent me. Well, now that I'm working for legal aid, I understand the importance of that paperwork, so I beg you to return it, but it's fairly straightforward. We just need to report the time that you spend, or at least an estimate of the time, to the people who give us grants. On the back of that sheet, it talks about collecting attorney's fees. We encourage our volunteers to collect attorney's fees in appropriate cases, and I'll let you just read that to see when those cases are. Okay, how do you advise somebody in a debt collection case? First, you need to remember, if you're at one of these advice clinics, let's say that you come to the clinic that's at First Baptist Church on May 8th. You have a client who has a debt problem. The client may or may not have been sued. They, as I said, frequently want you to put them in bankruptcy. So it's important for the volunteer who is giving advice, and it's only advice that you're doing at this clinic. You have no continuing obligation after the clinic. But when you're giving them advice, it's important for you to know what's going to happen after you get advice. Is that client going to get anything else other than the advice you give? And the answer frequently is they're not going to get it through legal aid. There is a list here of the types of cases that legal aid staff or the Pro Bono Project will accept for additional representation. But a lot of these cases we don't, because we just don't have the resources. So if you're talking to a client and it looks like, you know, they've got this used car problem, I bet if somebody just called a dealer, we could get this straightened out. There will be phones at the clinic. and you can call the dealer if you think that's necessary. But it's very unlikely that we at Legal Aid are going to accept that for the purpose of calling the dealer. Because we do thousands of cases a year and we generally don't have time to do it. If it's a case where you identify a truth in lending violation, for example, then we may take that for additional representation. There's a solid defense and the client would suffer a substantial injury. Then we may take that. But on this page, starting on page 2, it talks about when the client is likely to get more help. So when you're at one of these clinics, you're the lawyer. You're going to be giving advice. And what happens if you don't know what advice to give? Well, you're not going to be the only lawyer there. So we collaborate frequently. Typically, we collaborate. So if you're talking to a client, you're not exactly sure what the resolution to this problem is, excuse yourself from the meeting and go ask somebody else. We also have a huge number of brochures and what I call memos that I prepared. That I call them memos and not brochures, because if I call them brochures, they have to go through a committee to be approved. So there are a lot of memos which include forms like letters to creditors, asking them to stop calling, or stop calling a family member, or stop calling work. So on Exhibit 1 to the handout, there's a list of some of the debt-related information that we have. But we have a lot more than even what is listed here. So you have other resources besides your own expertise and experience to advise these clients. If your client has not been sued over whatever debt collection issue there is, well, I skipped a part. If you don't get complete information, we ask them to bring everything, all of the contract, which, they don't have because it was in the car that got repossessed, or they just never got a copy of it, or a lot of times they don't have the paperwork, and sometimes they forget to bring it. But if they don't have it, it's really hard for you to give them advice. So you can give them general information. In most situations, this would be what happens. Or in my experience, this is what this type of contract generally provides. Or they can tell you, I owe the debt. But a lot of times you have to say, I can't tell you exactly what you need to do because I don't have the papers. They may be satisfied with whatever you can tell them, or they may want still more specific information, in which case find a legal aid person and have us reschedule that person for the next advice plan. Give them a chance to bring the stuff in then. Okay, advising clients who have not been sued. These are clients who are under stress. They're under stress because they're afraid. The first one is they're guilty. They feel guilty because they're not paying their bills. You're not mental health counselors. You're there to give them legal advice. But when you dig down with them in an interview, you realize that there are some legitimate fears that they have that you can counsel them about. They're afraid that they're going to be arrested. This is a very common situation when they have been sued in General Sessions Court, and the court clerk in that county uses the form called a civil warrant. Our clients sometimes have familiarities with warrants, and they assume that this one is like others that they've seen, and they're going to go to jail if they don't go to court, or if they don't pay the bill. So you can tell them what the real consequences are of this. We have found there is nothing good that comes from talking to a debt collector. So we really emphasize, don't talk to a debt collector. We practice hanging up on people, because a lot of people can't do that. It's rude. They have a tendency to believe if I just explain my problem, they will understand. No, they're not going to understand. They have a script, and the script looks for a trigger, and everybody has a trigger. The little old lady who hears the question from the debt collector, do you have any children? Yes, I have a son. Oh, well, doesn't your son love you? And she doesn't want her son to look bad in front of this stranger on the telephone. So to avoid that person trying to contact her son, she'll agree to make payments that she can't afford to make. So it's better just don't talk to her. One of the things that's a legitimate fear is that collateral will be repossessed. I had a client a few years ago who they'll go into these small loan places and put up collateral. And it's usually a weed eater, a Game Boy, and a VCR. And it's all now missing, broken, and it's not something that the creditor wants. It is something that the creditor never wanted. They took it as collateral because it gives them some leverage. They know it's going to be broken and missing by the time this debt is in default. So they threatened the person with arrest for disposing of collateral. So it gives them a threat to use to collect the debt. It's not that they really want the weed eater. So that type of repossession is not really a risk, and they just need to be aware that the debt collector can't barge into their house to search through their stuff. What is a risk is the repossession of their vehicle. And there's a lot more detail on this section on repossession than you really will need in a typical advice clinic. I included that just to give you some context if any of this stuff comes up. But the main thing, of course, is that the creditor can't breach the peace when they're repossessing the car, which means that they can't enter into a locked fence or garage. They can't drag somebody out of the car. And it's difficult to know exactly what a breach of peace is. There's no specific definition, but it doesn't require violence. So it could be a breach of peace if the repo guy and the debtor never even see each other, if they have broken into a garage, for example. The main thing you want to advise somebody, though, is if you think your vehicle is going to be repossessed, take the car seat out. I can't tell you how many times the car gets repossessed and the baby's car seat is in the vehicle when it's repossessed, and now we don't know where it is. Tell them not to keep their contract, their financing agreement in the glove compartment. Because then when they come to us, they don't have a copy of it because it got repossessed. We have a lawyer on staff who loves car repossession cases. So if you're in a clinic, somebody looks like they've got a good case, which typically means the repossession has already happened and the creditor didn't follow the law in the repossession. They didn't give a notice of sale, for example. Then we're probably going to take that. Don't promise them we'll take it, but we at least want to look at it. Let's go over to page 10. And of course, repossession is a non-judicial remedy, so it happens without a lawsuit being brought typically. Did I have this foreclosure? No, deficiencies. Okay, there's a lot of information in here about how they can collect deficiency and what rules they have to follow. But because of time, let's go on over to advising people who have been sued. But these folks typically call us because they want a bankruptcy. So you've got to assess what their risk is from this debt that they've got. And frequently, low-income people, very low-income people, are judgment free. And there is no reason for them to file bankruptcy unless, and we have found these are the cases we'll take, they need to discharge a debt in order to recover their driver's license. In other words, they had a tort claim, usually from the other driver's insurance company. They filed a report that our client was uninsured, filed it with the Department of Safety. Department of Safety sends a notice that says you're going to lose your driver's license unless you ask for a hearing. But they don't really understand that letter. We love it when they bring us the letter before the deadline, but a lot of times they don't. So they never ask for a hearing. The reason we love it when they give us the letter first and we have a chance to find someone to represent them at this hearing is a lot of times the other side doesn't show up. So they get their driver's license back, fairly simply. But if they didn't ask for a hearing, or they had a hearing and lost, for whatever reason, they've lost their driver's license because they were involved in this car accident and didn't have insurance, we will put them in bankruptcy to discharge that tort liability to recover the driver's license. We also see people who can't get utility service because they have an old utility bill with KUB or whoever the provider is. While KUB won't give them utility service while the bill is outstanding, they really have no problem if the customer discharges that debt in bankruptcy. It's like no hard feelings, but you have to go through that process. Same thing with public housing. Say KCDC, they have a debt there, so they can't get into public housing. KCDC is fine if we discharge that debt in bankruptcy. So there are certain situations where we will handle bankruptcy, and I'm talking about a Chapter 7 because we don't handle Chapter 13. Does anybody in here handle Chapter 13? We have a lot of lawyers who accept their fee through the plan. So basically, it doesn't cost the client anything. Am I right?
Right, well, they're paying the fee, but it's paid through the plan over a long period of time.
So it's they're not paying any more to have a lawyer than they would be paying the creditor under the Chapter 13 plan. So we tell them to go find a bankruptcy lawyer to handle those. So those are the situations where we'll handle a bankruptcy. So if they don't file, and we'll definitely file bankruptcy if they have wages that can be garnished. And that means that they're making over $217.50 a week. So if they're over that threshold of income, we'll put them in bankruptcy to keep their wages from being attached. If they're making less than that, then the creditor can't do a garnishment. So if they're not eligible for bankruptcy, then the task of the lawyer at the advice clinic is to calm them down and explain what happens in court, and which is going to go through it. They're not going to get arrested if they don't show up. If they go to court and they don't have a lawyer, then before the docket is called, they're probably going to have, they're going to be called out into the hall by the creditor's lawyer, who has, 40 cases that day, and they'll line up at the lawyer's table. And this is no criticism of the creditor's lawyer. This is absolutely the most efficient way to handle these. The problem is that the client really doesn't understand what's going on. So the first question from a lot of creditors' lawyers when the client gets up to the table is, how much can you afford to pay? Because their objective is to get a payment plan. The client may not even be sure who this is. If it's a lawyer, is this the judge? Is it somebody else who works for the court? But they're sounding like, I have to make a payment plan. Sometimes they'll have enough courage to say, well, I could pay $20 a month. And the lawyer might say, we can't accept that. The lawyer's likely to say, we can't accept that. Sometimes they'll say the judge will never agree to that. So the client offers a higher amount. Or the lawyer will say, we couldn't accept more than $50 a month. The client will agree, believing that they really don't have a choice. But they can't afford that, so they're going to default on the payment plan immediately. So sometimes we tell those clients, don't go to court. You don't have a defense to the debt. And if you go to court, they're probably going to talk you into agreeing to pay more than you can afford to pay. And the problem is, we've had experience with clients who think because this is a court order that they pay, they need to pay that $50 instead of paying their rent. So a lot of clients don't need to go to court. In some situations, we will defend debt collection cases, even for someone who is judgment-proof. That's especially true if they may be judgment-proof now because they're out of a job, but they're not disabled, they're looking for work. When they get a job, then they're going to have garnishable wages, in which case we would put them in bankruptcy if they're still financially eligible for our services. But bankruptcy is really not a good idea for a lot of reasons, so we try to keep them out of bankruptcy if we can. So we may defend that case. And the reason that we defend a debt collection case, well, we don't defend them if the client owes the money to an original creditor, because that creditor is probably going to be able to prove the debt, especially if it is not a credit card debt. But when you get into credit card debts, even if the plaintiff is the bank that issued the credit card, so they have all the paperwork to prove that the debtor owes the money, there is no way that the debtor knows if the amount that the credit card company is claiming is correct. I don't know if you've ever tried to calculate whether the balance is accurate on a credit card statement, but it's tough because the interest rates vary. Sometimes they charge a late fee, sometimes they don't. These are just impossible to translate. So the debtor absolutely does not know if that amount is correct. And if there's a substantial risk to the debtor, then we want that original creditor to prove it, although in most cases, the debtor is not going to be in any different position if they have a judgment against them or not. And it's hard to go into Sessions Court and start calculating interest on a credit card with a general sessions judge. They don't want to hear that kind of stuff. So we may not take those cases. If the plaintiff on a credit card is a debt buyer, and it depends on who it is, some are better than others, we may take that case because there is a likelihood that we can get it dismissed. The reason we can get it dismissed is that the debt buyer doesn't have any documentation to show that the debtor owes the debt. So they'll give us several credit card statements that the original creditor sent. They'll give us this is typical, part of a document by which the debt buyer acquired the debt, but that document will, in most cases, be incomplete because they acquired 80,000 accounts when they bought our client's account. So they redact all the information about all the other accounts, and they'll attach the page that has everything blacked out except our client's name. But because they don't have the cover page, there's nothing to tie that to the debt or to the assignment. So it's difficult for them to prove the debt. Now, our client owes the debt. Why are we defending it? I can't tell you how many times we have had clients who have been sued by 2 different debt collectors on the same debt. So when you're dealing with the sale or purchase of, say, 80,000 accounts, mistakes can be made. So these accounts are often sold twice. So we'll have a client who, and this happens a lot too, they get sued, and they're sued by portfolio recovery. Well, I never had a credit card with portfolio recovery. So they don't realize it's Citibank who sold the debt portfolio. So they call, they say, you've got the wrong person. Then they explain, well, we bought the debt from Citibank. Oh, okay, I did owe that. Then they start negotiating. And they agree to pay $10 a month, or whatever they negotiate with the lawyer over the phone. Lawyer is going to take care of it. Or maybe they don't even reach a payment plan. But there is something said in the conversation that makes the client believe they don't have to go to court. So in those cases, a default judgment is entered. They may not know it. So they've got a default judgment by debt collector A. A few years later, debt collector B, revenue recovery, sues them. They don't know who revenue recovery is. They call the lawyer. I don't have a debt with revenue recovery. Oh, it's Citibank. Oh, well, I already got sued by Citibank. Something in the conversation makes the client hear the lawyer say, I'll take care of it. They think they don't need to go to court. Now they have a default judgment by 2 debt collectors on the same debt. So that's why we defend these debts. The creditor has the burden of proof. We ask the creditor to meet their burden of proof. And that's why a lot of them get dismissed. There is an additional problem that a debt collector has, which is there's a case called Mastow, and that's it's cited in your materials. What is it? 19. In Mastow, LVND, which is one of the large debt collectors, couldn't prove the debt. And it's kind of, the facts are kind of complicated, but the holding is very straightforward, and that is that each debt buyer in the chain has to prove that they own the debt, and they have to have somebody who was actually the records custodian for the business that created the records that they're trying to use, whether that be the records of the original debt or the records of the assignment of the debt. That's the person who needs to testify to authenticate the records. They can do that in person, or they can do that by an affidavit. But the debt collectors aren't going to be able to get somebody from Citibank to come in and authenticate those records unless they have done it by an affidavit that can be introduced under the authentication rule of the rules of evidence. They may have done that when they sold the debt. Otherwise, they're not going to be able to get the original creditor to show up to testify. So the evidence of the debt can't be authenticated. So these cases were getting dismissed. So the legislature decided that it had the authority to amend the rules of evidence. Is it appropriate, Justice Clark, to ask you if the legislature has the authority to amend the rules of evidence?
Yes, it's appropriate to ask. They do not have the authority to amend it alone. They must accept each year the rules presented by the Supreme Court. They may vote those up, or they may vote those down, but they may not amend them. What they sometimes do is pass statutes that appear to address issues in the rules of evidence, even though they don't say so.
That's what happened. In 2013, the legislature enacted a statute that basically said, yeah, well, that whole records custodian, we're going to say if you own the debt, your records custodian is really the custodian of all of the previous owners of the debt. So the plaintiff's records custodian can testify that the original creditor's records are authentic under the business records exception of the hearsay rule. We disagree at Legal Age. And we get a lot of cases, most of these cases get dismissed because they don't want to argue it. They don't want to argue this statute. If somebody's unrepresented, of course, they're not going to be arguing it, and they can still get a default or, a judgment after hearing. If you're representing someone through the pro bono project on one of these cases, we can give you briefs that we have that we think attack that statute sufficiently. We're looking for a case that we can take up and have the court accept our argument. But that's why we accept debt collection cases, even if the client says they owe the money. It may be in their best interest not to admit the debt. If the client is really low income, they can't pay it. So one of the things that we see in advice clinics is lawyers who don't normally represent low income people will say, just enter a payment plan. That'll keep your wages from being attached. And that is the advice that you would give to most people. It is frequently not appropriate advice for a low-income person, especially if their income is exempt. And on page 10, there is a list of exemptions. Wages up to $217.50 a week, as I said. And then most public benefits are exempt from attachment, except for certain, what I call in the debt clinic, super debts, like taxes, student loans, criminal fines and penalties, alimony, child support. Regular credit cards, medical bills, typical debts are not going to be attachable by the creditor. if somebody is on SSI and they're making $750 a month, they are struggling to meet their monthly expenses. I mean, that's just a fact. $750 a month doesn't go far enough to live on and pay these unsecured debts. So there is no reason for that client to enter into a payment plan when they can't afford it. So that's when you've got to deal with the stress and explain they're not coming after you, they're not going to take this money that you're making your Social Security benefits. We also tell them to file a notice of exempt property, because there's a $10,000 personal property exemption. So they can list up to $10,000 worth of property. And what I always tell them in the Saturday Bar Debtor Survival Camp is if I took everything in my house and I put it in the front yard and have a big yard sale, I wouldn't get $10,000. And it's flea market values that you're looking at. So they can protect all of their personal property, really, except perhaps their vehicle. So we talked to them about measuring the equity in their vehicle at forced sale, and that they start with that on their notice of exempt property and then work down from that. If they had $6,000 in equity in their car, they've got $4,000 left over to play with. So a lot of times what you can do at the debt clinic is help them fill out a notice of exempt property, and we have those forms for the client. Exempt assets are listed here. Their residence. A lot of our clients own their homes. You know, somebody is 80 years old, they've lived in that house for 60 years, it's paid for. They aren't earning anymore, their income month to month is maybe $750 a month. So they don't, their living expenses make a payment plan difficult, if not impossible. But they aren't judgment proof, because the creditor can get a judgment, record it, and now they have a judgment. Now, in the 35 years I've been, long time I've been practicing, I have seen creditors go after the house on judgment lien twice. Once was a lawyer from Colorado who had a judgment in Colorado for attorney's fees, had the judgment domesticated, and wanted to sell the client's house. The other one came up last week. And my fear is that because this creditor is petitioning to sell the debtor's house on I think it's $3,000 debt, that is a new trend that we need to be conscious of. That creditors are going to start enforcing these liens. But what typically has happened, at least in the past, is that they record the lien, they record the judgment in the registrar's office, that creates the lien, and they don't do anything about it. They just wait until the client tries to sell the house or mortgage it. And then when somebody does a title exam, they find the lien, and then they demand that it be paid out of the proceeds of the sale or the mortgage. And that's how most of them get satisfied. But my hope is that it's still going to continue to be the way it works, but my fear is that we're going to have people who are coming after the residents. On page 11, it lists the homestead exemption amounts, which in Tennessee range from $5,000 to $50,000, depending on the age of the client, marital status, and whether they have dependent children. Well, let's see, I'm out of time. Statute of limitations, there are some debt buyers who specialize in buying accounts that are past the statute of limitations. They do that because they really get those cheap. So, you know, we see these all the time where they're brought after the statute's run. It's an affirmative defense. You've got to raise it in order for the judge to recognize it. I've listed the limitations periods. In most cases, it's 6 years. Traditionally, this is not as simple as I perhaps made it sound, but traditionally, you think of the statute running from the date of the debtor's last payment. Although I had one yesterday with a client that sent an email saying, I want to pay this debt. So even though she hasn't made a payment, that would probably be enough to, for the statute to be running again. But typically it'll be from the date of last payment. And one thing you want to warn the client about is a debt collector who calls and says, just let me tell my supervisor that you're acting in good faith, just send me $5. Well, they don't want the $5, they want the statute of limitations to start running again. A lot of times we'll have, the client will owe a debt. There's no defense to the debt, but there is a defense to the add-ons. There may be a defense to the attorney's fees that they're trying to collect, or the interest rate. And I've gone through that, I'm beginning on page 15. An unlicensed creditor, and especially a title pledge lender, they can't collect, period. That's something that doesn't come up very often, but it's possible. Let's see. Any questions? David?
When you've got a client who's going to be going to general sessions, is it a good idea to recommend that they ask for mediation? Because they've got those volunteer mediators.
Right.
kind
I think there's no problem with that. If you've got a creditor who's willing to do it. And that would typically, from what I've seen, that's going to be generally not an institutional lender, although it could be. But especially if you've got a debt where they bought a camper from their next door neighbor, and then the camper fell apart when they tried to move it, you know, those kind of cases, a mediator is fantastic. So I don't know if you're all aware of this, but in Knox County General Sessions Court, they have volunteer mediators. And for pro se parties, where both sides are pro se, the judges usually identify them and recommend mediation at the beginning of the docket. But you can certainly mediate if both sides are represented or only one side is represented. The rest of the material goes through some very specific, did that address?
Yes, it is, thank you.
Addresses some specific types of debts that come up frequently. One thing that just is constant is people have a payday loan. That's where you write a check, you write a check for $100, give it to the lender, they take out $15 for their fee, and they give the client $85. Well, there's rules about rolling over these debts and not having debts in excess of a certain amount, but in reality, these debts roll over and they perpetuate themselves, and people have paid way more than the $100 by the time they come to us, because they continue to pay the fee. And what they're concerned about is that if that lender tries to cash the check, they're not going to be able to cash it. So the client's afraid that they're going to be arrested for writing a bad check. But These loans are called deferred presentment loans, and by the statute explicitly prohibits criminal prosecution. The reason is the lender accepted the check knowing it was no good. If they had the money to cover the $100 check, they wouldn't have needed the loan. So they're not going to be arrested for bad checks. There's some other common situations. I've put the statutes in the Exhibit 2 on the last page. It can be handy when you're in a clinic to be able to look those up if somebody puts in like a storage locker case or something like that. And I know, I'm way over. Any questions?
Did you get into the shared information?
We do, our staff attorneys do, we find it, question was, do we do Fair Debt Collection Practices Act cases? And yes, legal aid does. And we love it when a lawyer wants to take those through the pro bono project. So yes, but it's typically not something you resolve in an advice. Somebody else have a, yes?
I was wondering about like mobile homes that end up, if you got somebody that owns a lot and they bought it, they had a mobile home on it, and there's apparently no title, and it's been sitting there and it's been kind of passed down.
They're horrible, I hate those cases. And every once in a while, somebody will say, you remember that case involved a mobile home in Sevier County? Which of the 100 mobile home cases in Sevier County are you talking about? They are so common. Title problems, the mobile home gets repossessed, or they could redeem it, but they can't move it. If they move it, it'll fall apart. Yeah, huge problem. But a topic for another day.
This will be the last question, sorry.
Oh, I'm sorry.
No, go ahead, I just said this will be the last question so we can.
On the judgment lien, when they're trying to come after the residents, do they have to, because, you know, it's only good for 10 years.
Right.
Do they have to renew
Yes.
at the Register of Deeds office also?
Yes.
Okay,
Thank
Thank you,
you.
Terry, so much.